Good morning. Welcome to this webinar on Essential Construction Law Updates. My name is James Clegg. I'm the member of a Building Magazine editorial team with responsibility for the legal comment section. This webinar is supported by FenwickElliott. FenwickElliott is the largest specialist construction law firm in the UK. It serves clients internationally in the building, engineering and energy sectors. The firm provides comprehensive legal services on every aspect of the construction process, and since its formation it has always advised solely on construction matters, making it a specialist in the field. Joining me here today from FenwickElliott, we have Jeremy Glover. Jeremy's a partner. He specialises in construction, energy and engineering law and related matters. Typical issues he deals with include contract formation, defect, certification, payment issues, disruption, loss and or expense, prolongation, determination or reputation, and insolvency. Also, we have Claire King, who's an associate at FenwickElliott. Claire specialises in resolution of construction and engineering disputes, and she's acted on a wide range of both domestic and international construction disputes in power and water projects in Abu Dhabi, Jordan, Qatar, Oman and Saudi Arabia. On the agenda today, we will have the court's attitude to costs, is there a new approach at the courts, alternative dispute resolution, the court's attitude to adjudication, an update on BIM, followed by a Q&A where you can submit questions. You should be able to see how to do that on the screen in front of you. And now Claire is going to kick us off.
Thank you very much, James. Right. There is a new regime in place in the courts. It came into effect on the 1st of April 2013 and puts into effect the Jackson reforms. The new cost management rules apply to all cases commenced on or after the 1st of April 2013 that are proceeding on the multi-track unless fixed costs apply or the court orders otherwise or the court or claim is exempt, and any other proceedings where the court orders. The new rules follow on from a number of pilot schemes, including one in the TCC on cost management that ran from the 1st of October 2011 and ended on the 31st March 2013 and is the subject of a detailed report by King's College. There are currently a number of exemptions in relation to cost management that are worth going through. Firstly, the Admiralty and Commercial Court has a complete exemption at the moment. And then there's also provision in the rules for exemptions in the Chancery Division and the TCC Mercantile Courts as may be directed. The current TCC exemption applies to cases where the value of the dispute is over $2 million, and that excludes interest and costs. But it's worth noting this is under review by the subcommittee of the Civil Procedure Rule Committee and is subject to a fair amount of controversy. The results of this review were originally due last month, but the exemption still appears to be under consideration at this time. So what does this mean practically? Well, cost budgets have to be submitted and exchanged by the parties. They have to take the form of the new Precedent H, which was available from 1st of September 2013 and is more user-friendly than previous versions. There are guidance notes accompanying it to tell you how to fill it out in more detail. The parties need to file this 7 days before the first case management conference under the rules, or unless there's another date specified by the court in the allocation questionnaire. But there is a heavy penalty if you don't file this in time, which is that you will be treated as only budgeting for court fees. Legal fees, etc., will be excluded from the budget, essentially. What do you have to estimate for? Well, it's got to be reasonable and proportionate costs that the party intends to occur. So in filling in this form, you've got to think of reasonable allowances for all your intended activities in your litigation, so disclosure, witness statement preparation, expert reports, but also contingencies, which are by definition quite hard to anticipate. They're contingencies. You don't know if they will happen. So specific disclosure applications, for example. And you've got to think of everything from counsel fees, expert fees, court fees, and disbursements. So any copying, are you going to be preparing the trial bundle? You've got to anticipate that in advance. And budgets should be revised upwards or downwards only if there are significant developments in the litigation. And an application is required to revise approved budgets, especially where there's a case management order. And the key point to note is the courts will take your budget into account when it comes to assessing what costs you're going to get back at the end of the day, even when you've won. There's also a huge emphasis on proportionality of costs. It's enshrined in the overriding objective, so the court's going to take it into account in everything you do, and the court will resolve any doubts which it may have as to whether costs should be awarded, looking at reasonable and proportionality in favour of the paying party. It's also enshrined in the cost management process itself. That expressly refers to the overriding objective. So proportionality is at the heart of cost management. So costs incurred are going to be proportionate if they bear a reasonable relationship to sums at issue in the proceedings. Are your costs going to be $500,000 when your claim is only $300,000? The court will also look at other matters, including the value of any non-monetary relief, complexity of the litigation, any additional work generated by the conduct of the paying party, and any wider factors involved, for example, reputation or public importance. If at the end of the process you're awarded your costs, but it goes to a summary assessment and a cost management order has been made, then the court will not depart from that budget unless it's satisfied there's good reason to do so. So you're going to be bound by that. If there's no cost management order, then you still have to justify your reasons for an increase if it's more than 20% out, and the court can restrict recovery as well if it's over 20% out. So having gone through the basics, now I'm going to look at the approach the court is going through, the case is going through the system at the moment, just to give some practical examples of the problems being faced. And the courts are still very much feeling their way through these new rules, as the case law demonstrates. Probably the most well-known recent case is Andrew Mitchell of Plebbergate fame versus Newsgroup newspapers. Andrew Mitchell sued the Sun for damages arising out of the Plebbergate incident. The case was under the defamation costs management pilot, but it's very similar to the TCC one. Mitchell's solicitors completely failed to provide a cost budget 7 days before the first CMC. Now, the defamation pilot was pre-1st April 2013, but essentially it was sort of a transitional case because the hearing was post-April 2013. And the judge did actually impose a sanction under CPR 3.14 of only limiting Mitchell's costs to the applicable court fees. That sanction isn't actually expressly provided for in the pilot, but he decided he had the general power to impose that anyway. The judge decided there was no prejudice to Mr. Mitchell personally because he was under a CFA. And many claimants, I suppose, in the defamation side of things have no lawyers, so it wasn't going to prejudice a lot of parties anyway. That is going to appeal. It's obviously a very stringent penalty, but the moral of the story is get your budget in on time before you go to your case management conference. So another case looks at the principles to be applied when the judge is approving budgets. It's an application for permission to appeal. The defendant argued the judge was too generous in approving the amounts in the claimant's budget for witness statements and counsel's hourly rates. Basically argued that when you're looking at the budget, the court should look at whether the costs in the budget itself, as opposed to afterwards, are reasonable and proportionate and resolve any doubts in the other side's favour. Now, unfortunately, there's no binding decision. Appeal was granted, basically because the courts feel that more guidance is needed on the principles that are going to guide cost budgets. But the judge indicated that approval did not mean that costs incurred by the receiving party are reasonable or proportionate. So there's still going to be some assessment process at the end of proceedings. Another case which took place under the TCC cost management pilot scheme is Elvenite versus AMEC Earth, and it's an argument about indemnity costs and the relevance of the budget in those circumstances, but there are a number of key points that emerge from that judgment. Firstly, there can be no revision of a budget, and this was in the context of a cost management order after trial. An approved budget can be revised only by making a formal application to court. Merely filing a revised budget at court is not sufficient, and it's, in this context, Justice Coulson hadn't been aware that the parties had actually filed revised budgets prior to trial, so had conducted the trial as if it was on the basis of the previous budgets. The guidance was, as soon as it becomes apparent that your budget costs have significantly been exceeded, you need to file a new cost budget. And the court will only permit a departure from an approved cost budget if there is good reason to do so. The rationale is there should be certainty of costs for both sides, and that's what the new regime is aiming to bring. Slightly a contrasting case, National Museums versus AEW Architects. This is a pre-trial review. Revised budgets were submitted at the pre-trial review, but were not considered due to an oversight. In this case, it was held there were obvious reasons why costs had substantially increased, and in retrospect, essentially the revised budget would have been approved if it had been considered at the time. So the claimant in that case was not held to the last approved cost budget, demonstrating courts are still feeling their way on these new procedures and how to implement them. The next case, again another pre-trial review, looking at the budgets themselves and proportionality. Basically, Mr. Justice Coulson decided the budgets were disproportionate and unreasonable. They were costing, it was going to cost more to fight than they were seeking to recover, and he refused to approve the parties' budgets because he considered them to be disproportionate. Unfortunately, due to time constraints in this case, and luckily for the parties, no revised budgets were asked for because there was a need to focus on the trial, essentially. But it left open the possibility that the parties could be penalised for not having cost budgets approved. Although the judges say the absence of an approved cost budget should not mean that the parties could not recover their costs. But again, the moral of the story is get that revised budget in early. Don't wait till the pre-trial review. As soon as you know something's changed, get it in. And finally, just waiting for the slide to appear, Finesse Group and Bryson Products. Question of proportionality, and again, this helps if you're ever putting together a cost budget. The sum in issue here was 170,000. Parties' budgets each were 200,000, so more than the amount in dispute. And the judge issued a strong warning at the first case management conference, asked the parties to consider substantially reducing their cost budgets. They should come up with sensible and imaginative solutions to do this, for example, expert sharing. Otherwise, it was stated the court would assess and fix proportionate budgets. Luckily for the parties, again, the cost management couldn't be dealt with at the hearing, and there was a risk that the budget would be capped under CPR Rule 3.19, which limits future costs that can be recovered at a later stage. So an overview, the courts are taking their new powers of cost management very seriously. You need to get the budget right. There needs to be consideration in good time. Talk about it with the other side. For example, consider e-disclosure, what disclosure orders you're going to be asking for. Discuss, agree them. And if the costs go over or the situation changes, apply to the court straight away to amend your budget, or you will live to regret it.
Thank you very much, Claire. And I think one reason why we started the webinar today with the discussion on costs is because it demonstrates that there's clearly a new approach at the courts to litigation in general. And it's not just a new approach in the sense that there are new rules in relation to costs. As you can sort of tell from the discussion that Claire has just taken us through, the courts are actually taking quite a proactive role in dealing with cost management, and they're taking what can be seen to be, particularly for Andrew Mitchell, a very tough role in how they're dealing with things. And a lot of this is down to the revisions that were made in April to the overriding objective. Now, the overriding objective is it's the concept which governs every judge when he actually comes to deal with a case. And Claire's already mentioned that the overriding objective has been changed in order to deal with cases at a proportionate cost. As you can see from the current slide, it's also been changed so that the judges have regard to enforcing compliance with rules, practice directions and orders. And this might seem a simple, straightforward thing, i.e. a court sets a court timetable and it expects the parties to deal with it. The change in attitude and the new approach at the courts from April is that the courts actually mean it. And I just want to refer quickly to a couple of cases, both construction cases. The first one is Fons and Corporal Limited, and only really just to say what the message was. The message is, as Judge Pelling said, all parties in the wider litigation world should be aware that the courts at every level are going to take a much stricter view of the failure by parties to comply with directions. And it's a similar message from the TCC in London from Mr. Justice Edward Stewart. The claimant has taken quite long enough to bring proceedings, and enough is enough. They need to get on with it. And we mention that really because to make sure that people are aware that if you do find yourself in court proceedings and you do find yourself and there's a court timetable, this day and age there is less scope to actually get out of the timetable. But of course, if you have a good reason, the courts will always understand there's a good reason that more time needs to be taken. But as Mr. Justice Edward Stewart said, enough is enough. And that's an attitude I think parties over the next few years are going to find increasingly from the courts. And one reason the courts take that attitude is because of all the alternative ways there are to resolve your disputes. I think from the point of view of the courts, when you get to court, when you actually get to the stage where the dispute can't be resolved amicably or through some form of negotiation, the court views its job as being there to help manage the process of taking your dispute through the courts and, if necessary, to a final trial, and manage and direct that process in as firm and fair way to the parties. And one of the ways the court's always looking to you to sort of get off the road, get off the track to courts, is through ADR. And as is very well known, about 10 years ago, the courts actually said, well, sometimes parties need to be encouraged to try alternatives to court. And the sort of the Housey decision of the Court of Appeal suggested that if a party unreasonably refuses an invitation to engage in negotiation, an invitation to engage in alternative dispute resolution, then that party runs the risks of being penalised at costs. And by being penalised at costs, what we mean is there's a danger if you win, but you've unreasonably refused a genuine invitation to mediate, you might not get all your costs back. And what do we mean by alternative dispute resolution? Parties quite often talk about mediation, and I think I probably already have 2 or 3 times in the last couple of minutes. But ADR actually means what it says. It's anything but litigation. It's anything but arbitration. You don't have to have a formal mediation process, although it can be a good idea if you've got an intractable dispute. Have the benefits of having a mediator, a third party, who can actually try and assist the parties to resolve their differences can be very helpful. But it can be anything you want. You can face-to-face negotiation. You could perhaps get an expert in to try and resolve your dispute. And looking for alternatives to arbitration and litigation, that's usually a good thing. Potentially, and perhaps obviously, it's cheaper. And perhaps the biggest reason of all is it might work. You don't want to get involved in endless court processes. It's expensive. You'll find that your lawyers are continually asking you to do things when you've got better things to be doing, when you've got your actual proper job to be doing. And if you've got an alternative way of resolving a dispute, then it might work. It's probably worth giving it a shot. And the latest statistics from CEDA, who are probably the largest mediation provider in the country, is that the number of mediations that are being performed annually, year on year, is increasing. I think between 2010 and end of 2012, there's an increase year on year of 15%. But what's more important is that the audit also reported that information from the mediators suggested that there was a settlement rate of around 90%. And that's not necessarily each and every mediation settling on the same day. It's about 70% do settle on a day of a mediation, but a further 20% settle shortly thereafter. So it's always worth looking for alternatives. And the other message coming from the courts is increasingly that they want you to look to these alternatives. 2 or 3 years ago, the Master of the Rolls, the senior judge in the Court of Appeal, I think this wasn't actually a case, it was at a talk, the quote that's up on the slides, and he's saying that the court it's almost encouraging parties to look to mediation. He recognised that the court can't force you to, and hence he talks about leading horses to water, but he recognises the court can give you a quite nudge in the ribs, and that's a follow-on from the Housley decision and the ability to penalise parties on costs. And I think there's a more recent case, the PGF case from this year, which demonstrates that the courts are increasingly going down the line of, being slightly tougher in encouraging parties to at least give it a shot. In the PGF case, the matter actually settled because a Part 36 offer was accepted. Now, the slight twist here was that the Part 36 offer that had been accepted was one that had been made 7 months previously. Now, the normal rule would be that the party who made the offer that should have been accepted at the time, i.e. 7 months ago, would be entitled to its costs for that 7-month period. But what happened was that the court at first instance and then the Court of Appeal said, well, actually, no, you can't have your costs. And the reason you couldn't have your costs in this circumstance was because there was an unreasonable refusal to mediate. In fact, it was actually more than an unreasonable refusal to mediate. It was actually a point-blank refusal to engage in the mediation process. An invitation to mediation had been made, I think, a couple of times, and there was silence, and there was no response. And to be honest, pretty unsurprisingly, the court was not particularly impressed with that. The other reason that was put up by the party trying to get its costs was that at the time it would have been unreasonable to mediate because there was no chances of success. To be honest, that's an argument that the courts are not too keen on. And I mean, there might be reasons why you can't mediate. One thing to think about is that you can only mediate when there's a pretty full idea of what the actual claims are between the parties. So you might be able to say, well, we don't have all the information we need, therefore we can't actually mediate at this time. But one thing you must do in those circumstances, of course, is actually record that in writing, just in case, heaven forbid, 12 months down the line you find yourself in court arguing about whether that refusal to mediate was reasonable or not. And finally, on this topic, back to judges and judges of the Court of Appeal, and this is some words up on the screen from Sir Alan Ward in the case of Wright and Michael Wright, and they're interesting because it's a senior judge of the Court of Appeal saying, well, maybe it's time to review the rule in Housley and Milton Keynes, and what he's actually saying is maybe the time is to give the time is now to give the courts the power to actually compel parties to mediate. He's obviously taking on the quotation from his colleague, Sir Anthony Clark, from 2 or 3 years back, and he's actually running with it. We don't have a horse now, we have a mule. But it's an example of the frustration of the senior courts for parties who they see get stubbornly stuck in the litigation route and don't try and alternatives to settle. And it's an interesting comment, but the one thing to note about the comment is that it's a comment made by Sir Alan Ward in one of his, I think it's either his final or his last but one judgment before he retired. So he probably felt slightly freer than other judges may have done to actually make the comment. But it's interesting that they put a marker down, and I think increasingly over the next few years the pressure on parties to try and mediate and look to explore alternatives to resolve their disputes is going to increase. And of course, interestingly enough, one of the other alternatives to litigation, alternatives to arbitration, is actually adjudication. I'd like now to pass over back to my colleague Claire, who's going to update us all on the current attitude of the courts to adjudication and enforcing adjudication decisions.
Thanks, Jeremy. Can I just ask, I've just been asked to remind the audience that if you'd like to submit any questions, please do so as we go on. So moving to the court's attitude to adjudications and enforcement, just a bit of an overview. We've certainly, and this is anecdotal evidence, seen a rise in the number of adjudications in recent months, and there certainly seems to be a flurry of recent cases on adjudication enforcement from the TCC itself. Mr. Justice Aikenhead said at a recent talk at a FenwickElliott seminar that approximately 80% of adjudicated decisions that go to court to be enforced are enforced, so a very high percentage of them. And but he also observed that parties are asking the court to perform mental gymnastics often when they're trying to get an adjudicated decision overturned, essentially, especially when it comes to jurisdiction and natural justice arguments. So I thought I'd just highlight a couple of recent cases, almost to demonstrate the TCC's approach to jurisdiction and natural justice arguments, so you get a flavour of when it's worth combating enforcement and when it isn't. So the first case is Brims Construction versus A2M. It's a typical decision in the sense that it shows a very robust approach to enforcing an adjudicated decision. It was a payment dispute. The main contractor argued the employer had failed to serve a valid pay less notice, and they were therefore entitled to the full application amount, which was its default payment notice. A2M argued its interim certificate and pay less notice were validly issued. They raised jurisdictional and natural justice challenges to the enforcement of the adjudicator's decision. And in looking at that, Aikenhead emphasised you've got to look at the essential claim that has been made in your adjudication, notice of adjudication. He discourages esoteric arguments and contorted mental gymnastics, which are trying to find a way round enforcement. And also, the guiding factor behind this policy decision, adjudication is a process that's a relatively summary process. It's not full-blown court proceedings, and it's carried out under strict time limits. So the judge held that the adjudicator did have jurisdiction. It wasn't material that an alternative argument that had not been raised on behalf of the employer as the dispute built up hadn't been focused on particularly by the parties beforehand. It was obvious that the dispute was about the money that was due up to the 28th of June 2013. So the judge is looking at what is the overall dispute. And there was also no breach of natural justice. The adjudicator had asked for submissions on a specific clause that was mentioned in his decision. The other side tried to argue that this meant submissions was only on sort of legal points and that submissions didn't ask for factual evidence somehow, but this was dismissed pretty much out of hand by the judge. There's a very robust approach to enforcement that's going to be taken. There's also a couple of interesting points on waiver and jurisdiction that are worth mentioning in the context of this case. General points on waiver: there can be an effective waiver where a party challenges jurisdiction later, but has had the opportunity which it failed to take at an earlier stage. And the key there is, has the other party continued to participate, i.e. has it spent time, cost and resource in the adjudication? In this case, the parties were both legally represented. They'd made detailed representations, and it was 14 days before the issue of jurisdiction on the clause 4.11 point was raised. So the judge had no hesitation in saying A2M had waved goodbye to any right to object to the adjudicator's lack of jurisdiction. They had participated, they hadn't raised it early enough, and the application was dismissed. Another example of a decision being enforced is a Justice Aikenhead, and it's a Justice Aikenhead decision. The facts: the subcontract was dated April 2012, and it was for the interior refurbishment of kitchens and bathrooms. Clause 8 of the subcontract had the payment provisions, and Clause 16 had payment provisions if the contract was determined, and that provided that the main contractor will be liable to pay only for such works as have been by that date properly executed and shall be entitled to recover any loss or expense caused by such determination. At the end of the year, there were problems on site regarding periodic valuations and payments. Work was stopped over the Christmas period, and then there was a meeting on the 3rd of January, and it was agreed that they would not come back to work, although the works were incomplete. And then there was then a dispute about what was due to the subcontractor following departure from site. And the subcontractor said he was due money in his final account, and it wasn't the main contractor's valuation based on their post-contract discussions. Now, the main contractor argued he could rely on the termination provisions within Clause 16, and therefore there was no need for a pay less notice, whilst the subcontractor argued there was no payment notice or pay less notice issued within time, so therefore their final account was the default payment notice. The adjudicator held the agreement was not a repudiatory breach, and therefore Clause 16 did not apply, but he raised a different timetable for payment to that raised by the parties in the adjudication itself, and the enforcement was challenged. Did the adjudicator have jurisdiction to make the decision he did, and had the adjudicator breached the rules of natural justice in providing for a different timetable? So on jurisdiction, the court will have to analyse what the question or dispute referred to him was, and that might involve a detailed analysis of what happened before the adjudication, or it might just be obvious from the notice of adjudication or the referral. And in this case, the adjudicator had jurisdiction. The dispute that crystallised was what, if anything, was due to the subcontractor from its draft final account. Similarly, there was no breach of natural justice. The dispute was wide enough to cover the finding. There have been extensive submissions which provided, in the words of the judge, a variety of permutations, including that of the adjudicators, albeit the party hadn't expressly considered it. And the court should not have to carry out a relatively minute examination to find the final permutation in the exact form of the adjudication's decision. The courts are taking a practical approach. They're going to look at the overall dispute, and unless there's been a very material breach, they're not going to enforce the decision. They will enforce the decision, sorry. So a relatively rare case, moving on to ABB versus BAM Nuttall, looking at what will the court not enforce. And here it was held that there had been a breach of natural justice, and the decision was not enforced. So the dispute was the basis on which survey and design work would be paid for, particularly what were the terms of an agreement reached at a meeting on the 3rd of December 2012, and had a quotation been accepted by virtue of a failure to reply. The subcontractor won and was awarded nearly £1 million plus VAT on the basis that their quotation was accepted. But the key point was that the adjudicator referred to in a clause in his decision that neither party had ever referred to in the adjudication. And this clause provided essentially that there were no amendments except if expressly recorded in writing to the contract. The main contractor resisted enforcement. It was held there had been a serious breach of the rules of natural justice by the adjudicator because he decided a key issue in the adjudication by reference to and reliance upon a clause which neither party had referred to in the proceedings. There's a very handy summary of the law on natural justice in the judgment for those who are interested. But the key points, it must be a material breach of natural justice, and the adjudicator can't just go on a frolic. But at the same time, a frolic may make no material difference. So the question was, what would have happened if the adjudicator had asked for comments on that clause? So on the clause that provides that amendments have to be made in writing at that time. And the judge concluded there must have been a realistic chance that he would have said that the parties were bound by the agreement and that whatever happened thereafter was subject to that agreement. So it's a good example of how the courts are going to approach this. They're going to step into the adjudicator's shoes, essentially, at the time and ask what would have happened if he had asked for submissions as he should have done, and was there a good chance that the outcome would have been changed? And here the answer was yes. So if there has been a breach of natural justice, then the courts will obviously refuse enforcement. But the general trend is a very robust approach to enforcement. It will be enforced if possible.
Thank you very much, Claire. And for our final topic, moving on to something completely different, we wanted just to talk briefly about building information management, building information modelling, and BIM. And the reason for that is I'm sure everybody knows, BIM is one of the things that's on everybody's mind, on everyone's agenda when it comes to construction now and construction in the future. It's certainly firmly on the government's agenda for two reasons. It's a key part of the drive to reduce carbon emissions, and it's also a key part of the drive to reduce capital costs. And for that reason, it's incredibly important from a legal point of view, because it means we have to make BIM work. It's not something that can be ignored. And that's why, something within our office we're increasingly asked a number of questions about. And there are a number of legal concerns about BIM. People want to know what happens to my contract, who's responsible for the design. There's a whole host of questions up on the screen now. Now, I hope to be able to address most of these today, but I'd want to just put a small marker down that most of these are going to be addressed from a BIM level 2 point of view only. That is where the separate elements of design are put together in one federated model. We're not talking about IBIM or BIM at level 3 when you've got some kind of model up in a cloud where people can sort of be working on the same model at the same time. That's not level 2 BIM. But the obvious reason for doing that is because the current government policy promotes BIM at level 2 only. And the other actual reason for doing it is that most of the documents that we have published and documents that have been released at the moment only deal with BIM at a level 2 level as well. And we've now got up on the screen an example of some of the most important documents that we currently have available in the UK. We've got a couple of protocols up on the screen. We've got the RIBA BIM overlay and the RIBA plan of work, and that's a good example. So the RIBA are changing the way they operate to deal with not just BIM, but that's one of the key factors they're adopting. Then there's 2 or 3 contracts up there, and you've got the NEC guide to using BIM. And that's interesting in itself, in that many people want to know, how do I incorporate BIM in my contract? Well, the NEC haven't actually introduced any new contracts. They've introduced a guide to using BIM. And the basic way that you incorporate BIM, according to the NEC, and to be fair, according to the JCT, who've adopted a similar view in their public sector supplement, is that you use a protocol. The NEC says you use the CIC BIM protocol. I think, to be fair, the CIC protocol is a government-backed protocol. It's an official document. The NEC is saying that you ought to use it. So there's a point there to think about. People are saying you should be using the CIC BIM protocol, but it only came out in April 2013. And what this has meant is that there's a wide variety of different protocols out on the market. A number, particularly of the major design, major engineering companies, will all have their own protocol. So you need to know, be sure and understand what you're dealing with. And there's actually another incredibly important document which slightly unhelpfully isn't on the screen, and that's because it's never going to be a standard document. It's the employer's information requirements. It's what you need as an employer, what you need as a design team who are assisting an employer right at the beginning. The employer's information requirements are part of the process defining your BIM requirements, defining what the model is going to be, what outputs are going to be required. Your employer's information requirement will deal with technical areas, deals with details of software, definitions of levels of detail. It will deal with the management, who's going to do what, how is the process actually going to work. And then there'll be a sort of more commercial element to deal with timing and programming. But it's a key part of the tender document, and it's something that shouldn't be forgotten, and it's something that reinforces one of the key messages of working with and dealing with BIM, and that's early engagement. It's early engagement with the design team. Quite often it's early engagement with the potential contractor as well. And that, looking forward, looking to the future, is one of the ways that BIM is going to perhaps lead to a gradual change in the way that projects are working. This early development, early involvement of parties, and potentially, as we'll talk about later, leading towards the move towards a greater sort of collaborative way of working. So I've talked about a protocol. What are the key features of the protocol? Pretty much, it defines a code of conduct. It defines a code of contractual conduct, just like any protocol would. It's all about establishing the legal framework of the BIM, who's going to do what. It details the obligations that the parties agree to do insofar as BIM and BIM alone is concerned. It's going to set out standards. And what's important, and why protocols are important, is that you need a clear contractual framework to sign up to, and you need to get everyone to sign up to it. If you've got a contract with an employer, contractor, and a design team, it's no good just having the contractor and the employer signing up to the protocol. You need a wider engagement, and that's one of the key features of the CIC protocol. It's up there. It ensures there's an obligation on everyone who signs up to it to actually deal and actually to act as required by the protocol. And I think the primary object of your protocol is to enable the production of the design and enable the production of the design to be incorporated into your federated model at defined stages of the actual project. It's trying to say who's going to do what, who has a obligation to do what, and this sets, everyone then knows where they stand. It's simple, straightforward. The CIC protocol is a very short document. It's about 6-7 pages long, albeit it's got 2 rather crucial appendices at the end, which must be more project specific, and you can see there it includes the information requirements. But the other thing that the CIC protocol and any protocol calls for is an actual plan. The protocol is the who needs to do what, and then you have your BIM execution plan who actually sets it out in writing, the who, the what, the when, the whereby. And this again is a very important document. Sometimes it's known as an implementation plan. And I suppose from a project delivery point of view, it's actually much more important than the protocol. The protocol's there. It can be incorporated very easily to your contract just as an additional document as any other document would. The plan requires more thought. It outlines the overall vision along with the implementation details for the team that are working on the project to actually follow throughout the project. It's an important document that needs to be produced at an early stage in the process. There are some American BIM execution plans. There's one called Consensus Doc 301, and that requires that the BIM execution plan must be agreed and signed up to not later than 30 days after the early engagement of the owner-architect agreement or the owner-contractor agreement. And that's right. It's all there. That's how things should be. You need your map. You need your project program at an early stage, and the BIM execution plan is all about doing that. Your BIM execution plan, project team members are going to understand what they're required to do, understand their roles and responsibilities, and they'll know what they need to design, what level they need to design by, and when they actually need to do it. It's all about providing a baseline plan. And then you need someone who's going to manage the plan. And unsurprisingly, they're called the BIM Information Manager, although there are various other terms. Sometimes they might be the Model Manager. Bizarrely, sometimes they are the VDC, a Virtual Design to Construction Manager, a term that clearly isn't going to catch on. But it's, when you talk about BIM, who's going to actually manage the process? And the first question is, I suppose, who's actually going to be your BIM Information Manager? And I think to a large degree that depends on the nature of the project. If you've got a design build project, it's only right that the contractor should be able to appoint the actual BIM Information Manager. If other forms of contracts where the employer has a different role, or perhaps the lead designer has the more important role, you're going to find that the lead designer is going to be looking to sign up to the role or have someone from their team who's going to be the BIM Information Manager. And again, you can see the responsibilities of the BIM Information Manager on the screen. They're coordinating the use of BIM on the project, and they're responsible for managing, preparing, implementing the BIM execution plan. They're responsible for access, which is very key because people are worried about the design responsibility implications of BIM. Will people be able to tweak, change my design? Well, level 2, they shouldn't be able to do that. And you shouldn't, once you've had your federated model, I know that design is updated as you go along, and that shouldn't change. But there shouldn't be a capability for people to accidentally sort of alter someone else's design. But one person who's going to be responsible for policing that will be the BIM information manager. And of course, there will of course be a data history. In this internet world, we all leave behind a history of what we do on the net, and so the manager will be able to find out what's been going on. But the role of the BIM information manager, I was very careful to say, he coordinates the use of BIM, on a project. The BIM information manager isn't actually responsible for the coordination of design information. He's not going to have an ultimate design responsibility unless you choose, of course, to give him that responsibility. Mentioned up on the screen the PAS document, a sort of British standard, which is a very, very important document in setting out roles, responsibilities, how BIM, the use of BIM should be approached on projects. And it's one of the documents I mentioned on one of my earlier slides. I mean, if you're going to read documents, it's a very important document to read and try and understand, I think. And you may actually find that it's the type of document that will be imposing standards on your contract. Lots of people are very interested in the idea of, we have this standard here, can we actually impose that standard on my contract? And yes, you can. I mean, it's a fairly standard form addition to contracts that a contractor is expected to proceed according to a variety of British standards or building regulations. No reason why you couldn't incorporate PAS as the standard or obligation everyone must adopt. But even if it's not there being adopted, it's a useful document. It helps people understand and explain what's going on. And of course, one reason people are concerned about questions of design responsibility is when it comes to when things go wrong, when it comes to insurance. Now, the interesting thing about insurance is that, as you can see up on the screen, use of the CIC BIM protocol should not materially alter the risk profile. Now, CIC, at the same time as they introduced the protocol, also introduced best practice guide for professional indemnity insurance, and that was prepared with input from insurers. And one of the things they found out was that it shouldn't actually make that much difference to insurance. As far as insurers are concerned, of course, use of BIM properly, as you say, might actually lead to a reduction in claims. So the advice is, if you're using a BIM-enabled project, tell insurers. But as far as insurers are concerned, it shouldn't make any difference. And of course, even if the number of claims go down, it's unlikely that your premiums are going to go down. At level 3, it may be that there will be a change. And one of the things that the government is trialling at the moment is integrated project insurance, which is probably going to be the way forward in the future. Very briefly, just want to mention the CIOB Complex Projects contract. This is a brand new contract. It was released, I think, April, May of this year. It takes a slightly different approach to BIM to the NEC and the JCT. Remember, the NEC or the JCT, you incorporate a BIM protocol. The CIOB contract, which is, it's not just a UK contract, it's for use in contracts worldwide, sets out 3 specific options. The obvious ones, when work's designed by an employer, where the contractor does a bit of design, and where the contractor does the whole design, and then actually sets out within clause 11.1, 11.2 and 11.3 the various different responsibilities. For example, if the contractor is required to design the whole of the works, then obviously the contractor, well, I say obviously, but under this contract, understandably, the contractor will appoint the BIM information manager, and that gives the contractor, and the contractor has contractual responsibility for choosing the selected software, and that gets the parallel responsibility for being responsible for the integrity of that software. And the employer will be given a license to use the model to the extent that it needs to, when it's probably a design build. There's not going to be too much responsibility there. And there's a specific term that the contractor will be responsible for any clash, conflict or discrepancies that appear between the design and the building and the BIM model. And that's quite important to actually be given this specific responsibility to where there are sort of clashes. One of the big things about BIM is it's going to reduce clashes. It's going to when you actually produce your design. And this, when the works have been designed by the employer, I mean, the contractor gets a license to use the model, but no other form of intellectual property rights in relation to the model, federated model, or the design. And the contractor isn't allowed to amend the model. So it's the type of thing you would expect, and it's the type of, more importantly, it's the type of thing which is exactly how it is at the moment. Take BIM out of the equation, the different roles, responsibilities, and the different rights and obligations that you acquire, they're not actually changing. I think that's quite important, because it's one of the reasons why the government feels able to promote the use of BIM at a level 2 level. Very quickly mention BIM and facilities management. At the start of this talk about BIM, we just touched on the reasons why the government are promoting the use of BIM. One of the big savings is meant to be when it comes to actually operating your building. And I think the reason is because the records, it's felt, will be better. Instead of having your room full of as-built drawings, manuals, health and safety files, you're going to have your computer files. But it's not just about a saving in space, it's about actual detail. And it's about the detail that will be available to those who operate and manage the facilities. Should problems arise and you need to make repairs, etc. So I think in the future that's going to be particularly important. And finally, just one or two things to think about contractually when you're preparing to work with BIM. Remember to clearly define roles and responsibilities. Check you've got the BIM protocol, and check that you understand what the protocol says. But most important of all, remember that BIM is part of the design process. 100 years ago, it was said that a working drawing is a letter to a builder telling precisely what to build, not a picture to charm the client. The point that Edward Lutyens was making 100 years ago is that the important thing is the design. The important thing is that the building works. BIM isn't a shortcut to producing good design. It's something that assists in the design process. You've still got to get your fundamentals right. You've still got to make sure that the design works. And I think that's something, there's a danger that gets lost through all the talk about BIM, and people do tend to get carried away with the technology. And I think there's one thing to remember, that's the most important thing I want to say. Thank you.
Thank you, Jeremy, and indeed Claire. We've got a few minutes for questions now. Just before we get onto that, a few of you have written in and asked if slides are available to download. You will be able to do that tomorrow morning if you follow the link through here to the on-demand version of this webinar. And now, Claire, if we could go back to cost management, has there been any indication from the review committee when the decision will be made as to how low cost management will apply to the TCC? And also, what is the decision likely to be? That's from me. But Lewis Pereira has written in and asked, does this new regime on costs apply UK-wide, or is it limited to English and Welsh courts?
As far as I'm aware, and I'm afraid I'm not a Scottish lawyer, it's English and Welsh courts. In relation to the decision of the review committee, it looks like they're putting off the decision, essentially. We understand informally that a decision is likely to be made now in the new year, and the courts want a bit longer to see how the new procedures are going to work. We also understand it's likely, although this is by no means official, that cost management is going to apply to all courts equally rather than with the exemptions currently in place. But the courts may keep that under review. So if, for example, parties decide they want to go to arbitration instead, then that might change, which is something that I know TEXA and SCL were concerned about.
Okay. Kevin Turvey has written in and said, with the robust application of new court procedure rules described at the outset, again referring to cost management, it seems likely now that many or most adjudications will cost more than the equivalent litigation. Yet, in your presentation you said anecdotally you think you're seeing more adjudications at the moment. Have you noticed any trend in that, any move towards litigation from adjudication since these reforms have come in?
Certainly if it's a very complicated matter and it's likely to go on for a period of time, we would sometimes advise clients to go straight to the courts rather than risk having to do adjudication followed by the courts in terms of costs. It can be more cost effective. The key being that you're definitely going to get your legal costs back if you win at court. But equally, I would say that court procedures is much more detailed, obviously, than adjudication, which has a time limit on it, albeit that is often extended for a fairly lengthy period of time. So adjudication for low-value disputes is still likely to be more cost-effective than the courts.
Okay, thank you. And moving back to BIM, Jeremy, Andrew Turner has asked by Twitter, have you seen the CIC BIM protocol in action? I think he's asking, how has that practically been applied? Have we seen many examples of that yet?
Not as yet. The contracts that we've seen within our office that are currently being negotiated or projects going out to tender are actually not using the CIC protocol as such. They had used different alternatives, which is one of the reasons I mentioned that need to look out to there are lots of different options. So my actual answer is I haven't actually seen a contract yet with the CIC protocol. It looks like it's going to be more or less sufficient to enable the contract to allow for BIM responsibility as you go on, but it's provided that you've got the ancillary documents that go with it. It's provided that you've got your implementation or execution plan and you've got your manager in place. It's not just about the protocol, it's about the appendices to the protocol, and I think that's something that's quite important.
Okay, I've got another BIM question from Natasha Redden, who said, Jeremy mentioned that the BIM information manager should ideally be appointed by a leading party, which would be a designer. Would that not limit the BIM information manager's capacity to ensure quality of a process, in contrast to being external?
That's a good point. I think it probably cuts both ways. If the information managers come from the, if you like, the design team as such, they will have the advantage of understanding the design. But I can see what you're saying, in that you're saying an outsider has the advantage of not being constrained by being part of the lead design team. And the sort of slightly cop-out answer is that sort of what largely remains to be seen. A lot of the new roles that you get within contracts and within projects, when they first come out, it looks like there's going to be a whole new separate role for these people, and then it turns out in time the actual managers actually do start coming back, and they do start coming back from the contractor or the design type team. But it may be that the smart thing to do is to appoint your manager from a different party, but I think only time's going to tell with that one.
Okay. Question from James Brown saying, with regards to mediation, do you believe it would be reasonable to suggest it is not a suitable avenue if the monetary value of the dispute was vast in relation to the value of the contract? And they give, as an example, say a dispute which equates to 20% of the contract value. Mediation, I don't know which one of you wants to take this.
Sorry, can you repeat the question? Sorry, are we saying that there's a concern about the value of the dispute?
I think they're saying in high value cases is mediation appropriate as opposed to something more formal.
Yeah. Yes, I don't think it matters the value of the case, whether it's a huge case or a small case. The attitude of the courts is certainly that it doesn't make any difference whether it's a small case or a large case. All cases are suitable for mediation. And it's really a case of how you actually structure and set up the mediation process. Sometimes these can be, they need to be tailored to the value of dispute, and they can be quite short, but it's not unusual if you've got a very, very large mediation for it to be structured over 1, 2 or 3 days to give parties the opportunity to articulate the grounds of their dispute. And the funny thing is, mediation sometimes works in the most oddest of circumstances. You have these disputes where parties are complete loggerheads, and when they're forced to confront their differences, it can actually promote a settlement. And of course, the other advantage of mediation is you may be settling the underlying dispute, but one of the ways to settle the underlying dispute is to bring into play other projects and other potential avenues for work. You can resolve it in as commercial way as you want.
Okay, thanks. Do you have time for one more? Okay, another question from Kevin Turvey, fairly straightforward one. Do you know how much take-up there has been with the CIOB contract? That's the complex projects contract that's been introduced recently.
Yeah, as far as I'm aware, none as yet, but that's not surprising because it's a very new contract. It's still in its early stages. It's still being promoted and explained. We're in our office not aware of it being used. I'm not saying it won't be used at all, but it's there and it's sort of new and it's different, and it's got a bit of a tough job. In the UK, it's got well-established contracts, NEC and JCT. Internationally, it's got to sort of contend with FIDIC and to a lesser extent the NEC as well. I'm not sure about take up yet. I think it's the kind of thing that remains to be seen over the next couple of years.
Okay. All right. Thank you very much, both of you, for your time. Jeremy Glover and Claire King from FenwickElliott. And that's all we've got time for. So thank you for joining us today. There is the on-demand version of this webinar available from tomorrow. Thank you for listening. Goodbye.